Alrighty, so I thought I would pre-record some of this so that it would be just really concise and then I could participate in the chat with you and answer questions. So let's look at this together. Now, the whole objection to the demerer that I filed is 36 pages long, so we're not going to go over all of that. And we don't do that in the hearing either. So just to let you know what's going to go on in the hearing, the judge is going to already have read everything. She'll have looked at the writ, she'll have looked at their demerer, she'll look at my objection to the demerer, and then she'll look at their reply to that objection. So she'll have read all that. What judges do is sometimes they come in there with like a tentative idea of what they're going to do already, an opinion already formulated, and they have questions. So sometimes it's a really short hearing if they already kind of know that they think they're going to sustain the demerer or overrule it and allow you to go forward. So sometimes not. Sometimes they have a lot of questions. And what usually happens when they don't have a preconceived idea of what they want to do is they have you present all your legal arguments, but in a very concise way, not the whole document, and answering pointedly the questions that the judge has. So what I'm going to do here is kind of similar. I'm just going to go over what my main legal arguments are that go up against what their main objections are, and or their demerer. My document is the opposition or the objection to their problem with the case. So and a demerer is filed. I've told y'all this before, but for anybody that might not know, when they know that if we got into the facts, there'd be facts. But so they do think that the judge would rule in my favor if that were the case, but that they think that my case doesn't have sufficiency to bring a cause of action because of the way the laws are drafted. They're going to try to argue that I don't have the right to claim this relief as a third party or as a member of the public, and that I don't have also a cause of action to make certain claims. And I'm arguing that I do. So we'll go over that together. So looking here, what I did here was I first, of course, all the wonderful legal language, comes now, the plaintiff and all of that. And I'm showing them that my objection here is going to address their failure to provide sufficient legal grounds for dismissal. And because there's certain grounds you have to meet to dismiss a case, and they don't meet them based on the legal sufficiency of my complaint. And the way I wove this together, I hope it makes sense to you guys. It's literally everything you could come up with, and it's all truthful of what this makes this case unique, to where you can compel this corporation to act as a government entity here. So, which is what you have to do in order to do a mandamus action. And our case is weird, and we can do it. So the demerer fails to address key legal issues, and it improperly challenges the factual accuracy of the allegations. She does that in several points in her demerer. You're not supposed to address the factual allegations, and when she says things in it like the supposed crimes of Gatis Lagzdins, that's exactly what she's doing. And I can certainly prove up that Gatis Lagzdins is wanted for those crimes. So it was funny to me that a billion-dollar law firm would even do that in a demerer, but whatever. Anyway, I go into the background of the case, which most of you are going to be familiar with. If you're not, I can suggest several videos, comprehensive videos. One by Mortadella called This YouTuber Wants to Eat You. That's pretty good. And Rotten Mango's recent, still on YouTube today, telling about what Gatis did to Diane. So, there's plenty of videographic evidence out there where you could get like a quick 30-minute to 1 hour brief on what all went on here, and it's quite a lot. But the judge doesn't have the benefit of all that except for the links in my writ if she's viewing those. So I gave her a synopsis, the background of facts. I went into what all went on here, the doxing crimes, her fleeing him, then him being with Catherine, all the crime towards Catherine on these platforms, and his Spheria channel being taken down, Primal Belle. Then when the acid attack happened, the 2 arsons, and actually it was after the acid attack happened that the Spheria channel ended up being banned. I actually think that's kind of interesting. I definitely think the 2 things are related. I think they thought they'd better get that off of there, frankly. But anyway, and the judge may think that as well. We have the 2 arsons. We have the capturing of Ilias and Angelina, and of course we have documents, we have evidence of what they said, what the law enforcement has said. That's a matter of court record available to the public. I've got a couple of videos about some of it. Okay, there we have a warrant naming them, Gatis and Marina, along with Ilias and Angelina. Catherine's affidavit, all about what all was going on YouTube as well, and all these crimes, the revenge nudes and the extortion, doxing, terrorism, return of Diane to YouTube to tell us all about all this stuff, because I have to make the judge understand, how I became aware of anything and realized there was something a person could do, and why I was compelled to act at all as a third party at first. And then Ilias found guilty. Information about Lagzdins and Abdula revealed in the trial transcript. Then we have Gatis and Marina and the new endangered baby. And this is where we're going to come into play here, where they have a duty, an obligation, and it comes from an office, trust, or station. So they are an office in this case, but I'll show you all that in a minute. Incest promotion, that's another specific area of crime where you can compel action. And then the current scam he's running is another area where you can compel action. And also based on their violation of our contract as, the public, we're entitled to relief if you interpret that broadly like I'm asking them to. So they probably won't want to, but if they want to, they could. So current scam is one of many. And then I told them now the synopsis of everything that went on, the pre-filing and pre-litigation events, all of the cybercrime complaint forms and their responses and non-responses, the petition for the writ filed, and then when Ms. Perez saying she was investigating, but then when we spoke, she couldn't pronounce their names, didn't know what the Rumble videos were even mentioned for, even though it's expressly stated. So there was no investigation is what I'm citing there. That helps establish the fact that they really have no it's clear that they really have no desire to act here other than to just simply mitigate their own liability. They were never looking to see if they have a duty, and so the court will have to tell them that they do to ever accomplish that. Then I go in here to the other criminal Prussian who is threatening people online on behalf of this guy, including now myself by name. But initially, when I amended the writ, I was citing that he, in a general roundabout way, was threatening anyone who goes against Gatis and threatening to collect their IP addresses. So this is creating an atmosphere of fostering terrorism on behalf of this fugitive. So now I've been directly named, just like Sarah Norman had been. He told her that he knew where she lived and was going to fight fire with fire. I also now have had, by the way, guys, a fire threat that was on my other channel, my regular person channel. The person made it and then they took it down. It was a comment, but I screenshotted it. The avatar is somebody that looks like Elon Musk with like war paint on his face. So, and their name started with a K. Very weird, but it's one of their stupid sock puppet accounts. So, yeah. Okay, in the third conversation between the plaintiff and myself, she said she was going to file the demurrer, and she won't even acknowledge that they're the same man, and they never were really looking into deplatforming him, basically. So, new threats against myself are addressed there, like I just relayed. So, now we have my legal analysis. So, we get into the objections, okay? So, objection 1. I have to prove up that I am stating facts sufficient enough to constitute a cause of action. I'm entitled to relief under the California Code of Civil Procedure, Section 1085. So, in order to issue a writ of mandamus, the court has to compel, usually a government entity, but it can compel a corporation to perform an act that the law enjoins as a duty resulting from an office, trust, or station. Now, in this case, it's going to be under 18 U.S. Code, Section 2258A. They have a duty to report a missing or endangered child or any sexual abuse material related at children, where you're promoting that, to the National Center for Missing and Exploited Children and or to take it down. So he fits the bill on all of the above. And we have, of course, I go into explaining again how we do have a child with these fugitives, what all they're wanted for, and that the child with them would then, therefore, because the parents are wanted fugitives, be considered an endangered child. We have new law also, besides that, that's very, very important, the PROTECT Act, prosecutorial remedies and other tools to end the exploitation of children today. So that law mandates that certain entities, including private companies, report instances of missing or exploited children to the NCMEC. That obligation makes them a state actor. I also prove up later in this that they already do that when it comes to finding certain digital images. So any place where they already act as a state actor in that capacity helps my case. So the state actor doctrine, how do we determine if somebody's a state actor? A company is one. Delegated powers, state involvement, or coercion or encouragement. So if they have performed that function before, And I'm fixing to show them that they do. If they have state involvement, if the government is significantly involved in or has a relationship with the company, and they already do in relation to other instances where they report stuff. Coercion or encouragement. If the government coerces or encourages the private company to engage in the challenged action, they certainly do. And here's how they do. We have the Kids Online Safety Act and the Children's Online Privacy Protection Act. They aim to hold tech companies accountable for limiting children's exposure to harmful online content, improving online safety measures, and having tech companies and government entities having a symbiotic relationship when it comes to their safety. And they work alongside each other. They're supposed to have immediate reporting and cooperation with authorities under those acts. So, and we have down here also the AI used to detect new child sex abuse material content, similar to previously confirmed child sex abuse material content. They publish transparency reports detailing that to the NCMEC, and they detect and remove it. And disable accounts for violating child sex abuse material related law. Which Gatis Lagzdins, just by way of having that link to Telegram, she's trying to argue that that's not their problem. It is. You can't put a link to somewhere to go get your child sex abuse promotion on that website. They also already had him promoting it as Sfaria, and they took Sfaria down. So I think the judge will know what I'm saying. It's really obvious. They already had him promoting it on their website as Sfaria. He is the same guy, even though they don't want to acknowledge that, but they're calling him Gatis Lagzdins, and we know Gatis Lagzdins is both Sfaria and Gatis, which I can furthermore prove when we get into it, because we have him talking about his Sfaria Telegram, talking about his Sfaria channel being taken down in several Gatis videos from the past, him and Marina sitting on the bench lamenting it being taken down on his Gatis channel. So it's not going to be too hard to prove that Gatis and Sfaria are the same guy if I have to do that. And for the Demerara hearing, I don't have to prove that any of my facts are facts. It's automatically assumed that they are. So that helps me very much. But yeah, I think you get it, that I'm proving up that they already use the CSAI match technology to report things, that they have a symbiotic relationship already with government entities to do that. And so they already act as a state actor in that capacity, and that this type of crime applies to him in this case. Delegated powers, etc. I go further into details on all of those laws. So another thing we're going to get into is Section 230 of the Communications and Decency Act. They're going to try to say that I am barred for bringing this action by that act. And I'm going to argue that no, I am not. But let me go back up here because it ties into both things. So the Earn It Act, Eliminating Abusive and Rampant Neglect of Interactive Technologies Act, that combats online child sex exploitation as well. So it goes along with what I was talking about before, but it also goes along with what I'm about to talk about. That specific act limits liability protections under Section 230 of the Communications and Decency Act. So if they fail to take proactive steps, then they are not protected by Section 230. And that's what they're doing. So if the court doesn't mandate them to do it, they're not doing it on their own, they'll be liable. So that's why the court would then mandate them to do it. Reporting requirements that they have under that act are to report suspected CSAM to National Center for Missing and Exploited Children. And we have 2 wanted fugitives running around with a missing child promoting incest with a link to it on YouTube. CESTA Act, etc. Now let's get into the other aspects of the second objection. So Section 230, normally that provides immunity to platforms for content posted by third parties. They can't know everything that everybody's doing at all times and be liable for it. But that immunity is not absolute. So the FOSTA-SESTA package, enacted in 2018, it amended it to exclude protections for content related to sex trafficking and child abuse. We have his comments on the April 2023 live stream promoting sex trafficking of children using coded language. And then we have also the promotion, of course, of child sex abuse and the child that's with them. Section 230 does not provide immunity for federal crimes. And if you look down here, we have the Interstate Doxing Prevention Act. So, doxing and the act of publishing private or identifying info without their consent, it's not explicitly defined as a federal crime. However, certain aspects of doxing can lead to federal charges if they involve elements of harassment, threats, or other illegal activities. Well, gosh, didn't Gatis Lagzdins commit all of those activities towards Catherine Richard and towards Diane? I believe so. And no telling who else. So the Interstate Doxing and Prevention Act, I go into how he meets the standard for having violated it. And it's international too, mind you. So Alrighty, a corporation can be charged under U.S. federal laws if they help someone overseas violate those laws. This is particularly true if the corporation's actions have a substantial connection to the United States or if they facilitate illegal activities that impact U.S. nationals or interests. Do you hear that, Prussian? So, if a corporation's actions in any way assist and so that's a connection to the United States. We're an American company, right? Google and YouTube. Or if they facilitate illegal activities that impact U.S. nationals or interests. Well, we living here, if you're being scammed, running scams is considered something that affects our interest. Promoting crime, child sex abuse, or terrorism, that affects our interests. We're contract holders. We're affected by these laws. So, yes, absolutely, this meets that standard. And they actually could be charged. So, also a thing that she's trying to do is to act like I'm charging them with the crimes here, which is ridiculous and retarded. Obviously, what you're saying is that the court, if they don't mandate that action, they then could be charged. So, the court then would say, yes, this is something they have to do. And if they aren't doing it, we're going to tell them they have to do it. That's how that works. Sex trafficking. The Stop Enabling Sex Traffickers Act, SESTA, Section 230, excludes immunity for platforms knowingly facilitating or supporting sex trafficking. Now, here's the thing about all of this. They'll also try to argue that we didn't help him. Yeah, now you are. Because even if you didn't in the past know anything, now you do. So the fact that that's up right now and it's earning money right now, you're helping him. You're helping him evade arrest. He's committed terroristic federal crimes against other human beings, including children, and the sex stuff. So, yeah. Alrighty, where are we here? Sex trafficking, inducement or encouragement. If a platform is found to have induced or encouraged illegal content. So, did they do that? They're going to say that they didn't. So, the algorithm promoting him is a form of promotion. Now, I noticed a lot of other people that tried to use that don't win their cases. Some of them have. There have been a couple now where they actually have, or it's at least being appealed. But anyway, failure to remove him, despite all the evidence, is encouragement for him to continue earning money via their services. Once aware, they could put a stop to it, and failing to do so, including all illegal linked content, is a source of earned funds, and they earn money off of that illegal content and legal activity, by the way. There are people right now being charged criminally for earning money off of material that is illegal, basically. So that's interesting. That could happen to them in the future if the DOJ wanted to do that, which is another reason the court should mandate the action. Breach of contract. Now, this is important because she'll try to say, you can't bring an action for that. That's what she said talking to me, but I know better. Depends on how broadly they want to interpret the statutes. And I know that, and she knows that. So, breach of contract. Platforms can be held liable if they breach a contract with users or fail to act in good faith. Gatis Lagzdins was banned as Faria for violating the community guidelines. He was banned from PayPal and Patreon at that time as well, but his Goatis channel remained. Despite making the platform aware of this repeatedly and of the serious crime involved over a span of many years with what is now a wanted fugitive, they not only failed to make any reports, but leave him on the platform to earn money as he evades arrest. So they're breaching contract. Failure to warn. If the platform fails to warn users about illegal activities occurring on its services, it may not be protected. Are they warning people not to give him money? Are they? Are they warning people not to interact with this man, not to go to that link on Telegram? Yeah. So case law related to the Section 230 exceptions. I've got lots of case law here related to all of this. So, but you get the point on that one. Okay, and we'll try to be a little quicker with this because I just realized I'm talking for a long time on all of them like I'm actually in court. So let me not take up too much time. But on Objection 3, so I have to prove up that I state facts sufficient to state a cause of action for violating the Anti-Terrorism Act, which I accuse them of doing, which they are, which is 18 U.S. Code Section 2333. Alrighty, so she called that absurd, which is ridiculous because this is not the only platform that's ever been accused of this or the only instance, and they've been accused of it before by other cases, so no, it's not absurd. Alrighty, U.S. courts can hold corporations liable for aiding and abetting acts of international terrorism. Now, there are certain rules regarding international terrorism where it really is more akin to talking about an American who is a victim of terrorism from somebody from another nation, whether they're in that nation at the time or it's somebody that comes here and does something. But you can interpret this more broadly, so that's what I'm trying to do here. Judge may not go along with it, but we'll see. YouTube Google LLC was made aware via comprehensive evidence of several acts of terroristic crime committed by Gatis and Marina, which constitute a violation of the ATA. But you also have to take into account that are they a danger to people in this country in terms of terroristic crime? Yes. Is Prussian in this country threatening to do things to people over this guy? Yes. So this all adds a new dynamic that assists with that claim. So Catherine Richard, she talks about what he says he wants to go out and do to people. I go into all of that. He wants to harm other people in the future. Kill babies, do all this crazy shit. And what he was planning on doing to her, Diane, and her son, and what Catherine was helping with, and Florian. And then Catherine flees and waits a year to tell everybody, but nonetheless, and then what all he did to her before that, threatening her at knife point to have those videos of her body taken and just given to other people, along with all of her identifying info and of all of her family members, with it being suggested that they be harmed. It's clear that that's the suggestion. Bloody good time, this is all a terroristic crime, violating several different things, but I think it fits under the framework of the ATA to terroristically threaten people into getting offline, shutting their mouth about crime, all of that kind of stuff. Silencing witnesses. There are specific laws about that, and that's kind of what was going on with Catherine. So, proof of a cause of action for promoting terrorism. So my hyperlinks and details of the crime in the affidavit that Catherine gives, coupled with the warrant, the trial transcripts, and the company's own supposed investigation, this all would be enough to constitute a cause of action for promoting terrorism. All of that information that should be gathered from all of that. Evidence of intent. The content shows the creator intended to promote or incite terrorism. These are the elements you have to prove up ATA violation. So yeah, he had the intent to terrorize others and incite others to do things as well, is even further into the category of terrorism. Material support. Does the content provide material support for the guy? Absolutely, it provides money for him. And so funding him and financing him as he evades arrest, advertising his crypto wallets and linking to other sites, absolutely. The section of code does not have to be applied to an organization. It can be applied to an individual. I remind them of that. Context and impact. The context in which the content is presented and its potential impact on viewers is crucial. Is it likely to incite imminent lawless action? Yes, it has and is. When Gatis Lagzdins doxed Diane, he told his fans to call the Dutch authorities, file reports on her, and they did that. When he doxed Catherine and shared sextortion videos, it was downloaded and put all over the internet. Luckily, nobody went and attacked her family that I know of, but that was the intent in providing that information and telling them to show him true natural respect. So, and then on his Black Pill community content, I bring up that he also was trying to encourage people who he thought were disturbed or hopeless to go out and do these crimes. Under the Anti-Terrorism Act, 18 U.S. Code, Section 2333, the following actions taken by the company once aware can constitute violations. Aiding and abetting or material support. So, they're providing assistance for those who are committing or planning or authorizing acts of international terrorism, potentially. They already have done it. So I have case law showing that if they've ever done it before, you can assume they would do it again. So to provide them assistance right now, knowing that is aiding and abetting, I'm arguing. Material support. Are they knowingly providing material support or resources? In the form of money and the potential of getting money, I say yes. They will, of course, argue that, no, we're not. We're not supplying him with, sulfuric acid or anything to commit terrorism with. That's absurd. But anyway, violations can lead to civil liability, allowing the victims to sue for damages and attorney's fees. That would be Diane or anybody else harmed. And it's used primarily, I go into how it's primarily used, but here's what you do when you want to get them to extend it into other areas when they potentially could. And this is how this could set precedent. They won't like that. Is you try to look at what it legislatively was trying to do. So I'm putting how there are direct threats to U.S. nationals by way of these new threats to people who are supportive of the victim and who are against Gatis being threatened. And how when people face no, in a broad way, when people face no consequences for this behavior, and you're making it clear that they're not going to, you're just going to assist them and ignore whistleblowers and even put them in potential harm's way, you're fostering a culture of terrorism. the complicity of the company, once aware that they're being used that way, they're complicit in the potential harm to U.S. nationals, and this fits the standard for wanton violation of the ATA. That's what I'm arguing. Legal obligations under the ATA. They're required to prevent and report any support for terrorist activities, including taking down fundraising efforts and providing information to authorities. And then I give them a lot of case law. So, objection 4. The petition states facts sufficient to state a cause of action for violating federal anti-terrorism statutes. And that would be under the same code, but it's 2339A and 2339B. So that goes into breaking down the material support portion, where I go into how we're talking about financial services in our case, because this is law that's mostly written about terrorist organizations who are being assisted in other endeavors, but that one part would be the part that we're relating it to here, where currency and financial services. And then knowledge and intent. The defendant knew or intended the material support would be used for terrorist activities. Now, of course, they're going to argue that they didn't know that and don't know that. They're arguing that they right now don't know whether he's really a criminal or not. That's the part where I'm finding fault with them. They do know. They absolutely know. So, YouTube and Google are now aware of the serious terroristic crimes that Gatis and Marina are evading arrest for. They're aware he was previously banned as Feria, although their representative refused repeatedly to give the direct answer of yes or no to that question. They have no excuses left for continuing to allow them to profit on their platform. With knowledge now that the material support could be used for further terroristic activity, and that until apprehended, Diane and her son are hiding from another attack on their lives. Their inaction is not only morally inexcusable, but since it now affects the safety of U.S. citizens, it violates the ATA due to their inaction, and the court must mandate the action. And then the material support. Okay, they knowingly right now would be providing material support in the indirect way of allowing them to fundraise there. And let's see, the organization receiving the support has been designated as a foreign terrorist org. That doesn't apply here. You don't have to have all of these in order to violate B. So I'm arguing that we have 1 and 3. Knowledge and intent. The defendant knew or intended that the support would be used to further the terroristic activities. In this case, an individual, not an organization. But the defendant knows now, defendant being YouTube and Google. They know now that it likely could or would, and that would be enough. So, and I go into how we can be talking about an individual, knowingly emboldening that behavior. Okay, objection 5. And once again, the ATA is not my biggest argument. If those get struck down, we still can go forward and accomplish this. But no harm in weaving that in there because I absolutely think it applies. Okay, so objection number 5, I have to prove that I state facts sufficient to state a cause of action for violation of the Computer Fraud and Abuse Act, or 18 U.S. Code Section 1030, called the CSA for short. So let's see, that statute can be applied to hold a social media company liable if they allow a content creator to defraud others on their platform. Wow, guys, has Gatis Lagzdins defrauded others on this platform? I mean, just never, according to him, but let me think back. I seem to recall a camera that he says that he left on top of the car or something, and then someone stole it. He thought they must have stolen it. He couldn't find it. I think he even said he might have made a report trying to get it found, and he needed help and money to get a new camera. And then lo and behold, he found the camera. So, and he decided he was just going to keep those donations. He was going to go to a bunch of vegan events, and then he didn't do any of that, and he kept those donations. And most obviously scams would be the one where he said that migrants beat up his girlfriend, and his girlfriend is now here telling us absolutely not. He did that, and it's in line with other things he does. So we've got that one. I believe her that was a scam. The other scam would be, I want to see my son. We know that there's no record of him approaching a court to see his son ever. And we have documented evidence of her laying out guidelines for him seeing the son. And all he did was threaten her in those communications about getting off of Patreon. He didn't demand to see his son at all or ask to or anything else. So there was never any action on his part to hire a kidnapping lawyer either. That is his current scam. So that's a lot of scams, and I don't know, there's probably more than that. But yeah, and I go into that in here and I tell them about those scams. But the CFAA criminalizes unauthorized access and fraud related to computers and computer systems. Now, that goes into things where a place where someone works where they have access to certain types of information, and they're allowed to access that information in order to run scams or access those computers in order to run scams. So that's one type of computer fraud and abuse, but this goes into fraudulent activity and other types of computer fraud and abuse here, and those are the ones that we're talking about where Gatis is concerned. So if a social media company knowingly allows fraudulent activities to occur, they could be held liable. So in this case, it's not only the current activity, but the prior aspharia. So I tell them how we meet the standards for fraudulent activity. I tell them all the evidence in the writ, all the shit he's done, and platform's knowledge of it. That has to be there. So the social media platform knows about the fraudulent activities and is failing to take action to stop them, which is why the court is being asked to get involved and mandate the action. Causation. The platform's inaction is causing more donations to be made to this wanted fugitive, which prolongs the harm and suffering to those at risk. And it harms those who may be in good faith right now donating without knowledge of all of these facts. And that matters a lot, guys, because, good faith donations being given and the company's awareness of that fact is that that could be occurring. There's specific laws tied to that I get into later here. But anyway, the defendants are hosting the scam, and they've been made aware of that fact. So let's see, we go into the fraud provision. There's a fraud provision part of this particular part of law, and intent to defraud. So the defendant has to have intent. So in this case, the defendants, and remember, we're talking about YouTube and Google when we say defendants here. So Gatis and Marina are third-party defendants in this case. So the defendants are fully aware of the scams. If they leave them up to continue to grow as people donate, then those people are being defrauded. They have intent to defraud in that instance because they're fine with them being defrauded and they're making money off of the content. So you can't argue that. And then furthering the fraud, they're allowing him to access the platform where he obtains money via the scams. Damage provisions. So intentional or reckless. The defendant must have acted intentionally or recklessly in causing the damage. In this case, they intentionally turned a blind eye to the scams and the crime and the fact that he was already banned. It's reckless as well to have brazen disregard for what harm could occur when leaving the current scam up on their platform. And that includes to us as, contract holders, all of the innocent people who may donate. They violate the public's rights there in such a way where it's the very type of thing where they have an office, trust, or station related to FTC law and not running scams, not hosting scams, not assisting with scams, not turning a blind eye to scams. So we're into Objection 6 now. Okay, so Objection 6. I have to prove up that my petition states facts sufficient to state a cause of action for 18 U.S. Code Section 2258A because a criminal statute can create a private right of action in this instance. And that's kind of an unusual thing. It has been argued in cases using law this way where usually it's not a private citizen who can sue this way, but it can be done if you interpret it broadly, and I'll make that make sense if I can. So in our case, this particular piece of code, it outlines reporting requirements for providers of electronic communication services and remote computing services regarding child sexual exploitation. And of course, we've gone over how Gatis Lagzdins is promoting things that do that on their platform and has in the past. Now, to pursue the cause of action, you have to rely on other statutes to kind of be coupled with this. So the ATA and the CFAA, as previously discussed, do that. But in addition to that, a private right of action is implied because the public interest in protecting children from exploitation is the legislative intent of that law. So how law gets interpreted, anytime you hear that something's been argued before the Supreme Court, that's what they're arguing about. You would think, well, the law, it either, applies or it doesn't, right? Well, not really, because people draft laws and then every situation is different. So you look at that situation and you say, how does the law apply to this situation? Can it apply this way or that way? Should we change the law a little bit and expand how it applies so that we can cover situations like this? So in this situation, I'm arguing that the reason that law was drafted was in the public interest of protecting children from exploitation. So allowing private citizens to try to help it be enforced aligns with that goal. And the congressional intent, the Congress intended to create an effective mechanism for protecting children. So that includes empowering individuals to act, and precedent and analogies. So I found different things that set precedent, and they're kind of analogous to this, but whether that will be determined to be my way or their way, we shall see. We don't need it to go on and litigate this case, but why not throw it in there, because it could definitely apply, in my opinion. And then we have some good case law here. Equity and fairness is another reason. We are trying to prevent harm. Courts are supposed to be all about equity and fairness, so I'm arguing that we're supposed to prevent harm. Denying a private right of action here would undermine the statute's purpose by leaving victims without a remedy. Public policy, the interest is in protecting the vulnerable. And we've made them aware of their duty of care here. Judicial interpretation. The broad interpretation to fulfill the purpose should be used, is what I'm arguing. And the judicial responsibility, the courts have a responsibility to interpret the statute in a way that ensures effectiveness in protecting children. So, and I further cover why, while it doesn't usually provide a private right of action, the legislative intent and public policy considerations support the inference of such a right. So that's my argument there. And then I have even more case law. So we're down to 7. Don't worry, there's only one more, but here we go. So my 7th objection is the petition states facts sufficient to state a cause of action for 15 U.S. Code Section 45. So that's part of the FTC Act, and it declares unfair methods of competition and unfair or deceptive acts or practices that affect commerce to be unlawful. And we've been over the scams. You guys know what all he's done that does that, and that they don't apply their terms of service or community guidelines fairly and evenly to all of us violates this, and we're the public and we're owed that duty of care. And that's the type of duty, anything involving this type of law, that can be mandated by a court because they have an office, trust, or station under FTC law to do it. Now we see elements proving it up. Unfair methods of competition. The defendants engaged in unfair methods of competition when they allowed Gatis to have a second channel after being banned prior, hosting not one or two scams, but multiple scams and links to illegal content. That takes away their Section 230 protections. Unfair or deceptive practices. When you allow scams and you're aware, you're being deceptive and you're doing something unfair. Public interest. We're allowing a private right of action here would serve the public interest, just like in the other instance it does. So that statute also normally doesn't provide a private right of action, but I just outlined there why it should. Alrighty, we're on to objection 8, the last one. So the following causes of action are clear in the petition, and these are California Penal Code, Section 422, 245, 653M, 273A, 11418, and then 47 of the U.S. Code. Now, in the Demerer, she makes it sound like she is just so confused as to how those could ever be applied to them. But I make it very clear in the writ, and I reiterate it here. So let me tell you guys that CEOs right now of corporations and corporations themselves can be held liable for crimes. The DOJ can bring a case against them, and CEOs specifically can be charged with crimes even, and some have been convicted. In the instance that I'm thinking of, one was convicted of contributing to human trafficking and rape and things of that nature. So in these cases, we've got all of these crimes that they're contributing to. Let's look at what they are. Criminal threats. A person willfully threatening to commit a crime resulting in death or great bodily injury to another person. Well, we've got that going on right now with Prussian. We've got that going on with Gatis Lagzdins in the past, and right now his presence is a threat. Since he's already done that in the past, there's case law showing that if he even could possibly likely be going to do that in the future, and they're aware of it, they're obligated to act. Section 245, assault with a deadly weapon or a force likely to produce great bodily injury. And there's key elements of these different bodies of law. So we have assault, the assault itself, and then the weapon or instrument has to be something that would be creating a force likely to produce great bodily injury. 653M, annoying or harassing electronic communications. Well, absolutely, he's done that. He's used this platform to beyond annoy and harass, but outright threaten. Having people call Dutch law enforcement agencies on Diane, like a smear campaign of terror, basically. And then, of course, making these accounts where he doxes people's entire families and gets people to, encourages them to go and do something to people, which would scare, harass, annoy, and intimidate these people. And he's doing it for the purpose of intimidating witnesses or people he wants to keep their mouths shut, talking about him in the case of Diane, or make them come back. And if they won't, he's going to kill them or use the computer to terrorize them. So, yeah, we have all the elements of that one. California Penal Code 273A, that addresses child endangerment. So that would be the child on his lap in the scams and the child in hiding. And the company is facilitating that, continuing. We have all the elements of that there. I won't go over all that. 11418, possession, development, manufacturing, production, transfer, acquisition, and in our case it would be acquisition of a WMD. That would be a chemical weapon like sulfuric acid. And so we have Gatis Lagzdins in possession or control. He's the third-party defendant of the chemical concoction that he put somewhere for Ilias to get, and the company is aware that he's wanted for that, and he's evading arrest, and they're helping him earn money. Lawful authority. The defendant did not have lawful authority to possess or control the chemical weapon. I don't know about that one. I don't know if you can run around with sulfuric acid, but I would assume you shouldn't. And then in our case, we have its chemical weapons. And California Penal Code 11418 has to do with the same thing. Okay. So in this case, and I'm not kidding that it's a weapon of mass destruction, a chemical weapon like that. It's an agent used to bring bodily harm to someone. And I'm not kidding that we are talking about WMDs. A chemical weapon is such. Knowledge, facilitation, or intent. So once again, it falls under the category of the company knowing about these illegal activities. Are they facilitating him to do transactions on the platform that could result in him doing something like this? And intent. Do they have the intent to support or enable? And in this case, turning a blind eye might as well be the same thing. Supportive case law, criminal threats, and material support case law. And so, yeah. So 47 U.S. Code is what I was citing. Now, I had put 49 in one place, so she tried to use that to say that it was just nonsense. But yeah, 49 would be nonsense, but 47 is not. You're allowed to fix a typographical error in your objection, so I do that here. 47 U.S. Code is what I'm referring to, and I state very clearly how it applies, just like I did in the writ. But 47 U.S. Code has provisions related to the regulation of electronic communication by way of the FCC. So this is applicable in cases where social media platforms are involved in hosting or facilitating criminal activities. Well, gosh, we know they've done that for years with him, and they know it now too. So the California criminal codes were cited to illustrate that should the court not mandate the action, the defendants could potentially be held liable for some of these crimes, depending on their awareness, and they could be held liable in the future for knowingly facilitating criminal activity that's currently occurring. The reason the California criminal codes were cited was to illustrate that should the court not mandate the action, the defendants would be held liable potentially for some of the crimes, depending on their awareness, and they could be held liable in the future for knowingly facilitating the activity that's currently occurring. So the criminal activity that's currently occurring in the form of the scam to raise funds while he evades arrest, evading arrest is another crime, and any crime in the future, if any of that money is used for such, they have an awareness. So the court needs to mandate the action since that awareness hasn't made them take the action. And my conclusion is asking that they deny the demur. They grant the writ of mandamus immediately, compelling the defendants to perform the duty as required by law, or in the alternative, schedule a hearing to address the matters raised in this petition. Grant any other relief that the court deems just and proper. Just as they did that with me, I'm doing that with them. I feel like their actions certainly fall under the guideline of being reckless, frankly. And mine are, if the court wants to be punitive towards a third-party whistleblower who now has somewhat put themselves at risk to do this, and it involves this serious subject matter, then I'd like there to be a record that they did that. That would be pretty ridiculous, and I don't think they'll go that far.